Now I am going to dictate a legal passage at the rate of 120 words per minute based on latest judgment of the Kolkata High Court. Let's start. MS Paul submits that the alleged accident happened on 02/07/2019 and the victim succumbed to his injuries on 03/07/2019. The FIR was filed on 05/07/2019. She submits that there was delay in filing FIR and the delay was never explained properly by the claimants. She further submits that the offending vehicle was not at all involved in the alleged accident. She further submits that the inquest was conducted upon the dead body of the victim. From the said inquest report, it would be revealed that the victim was dashed by an unknown vehicle. Mr. Mondol, learned advocate appearing on behalf of the claimant, submits that the ground for non-involvement of the offending vehicle was not properly proved by the insurance company. He further submits that the FIR was lodged just after 2 days of the death of the victim, so it is quite reasonable that the de facto complainant, who is one of the brother of the deceased, must have engaged to the final rituals of the victim. He further directed that there is no evidence to substantiate the plea of the insurance company regarding the non-involvement of the offending vehicle. He further submits that the inquest report was not exhibited before the learned tribunal. Thus, there is no justification to entertain the ground. It appears that the FIR was lodged by one of the brothers of the deceased on 4th September 2019. Though the police case was started on 5th September 2019, it further appears from the FIR that the de facto complainant was engaged due to the final rituals of his brother. Thus, he lodged the FIR after 2 days of death of his brother. I find justification to doubt on that. It further appears that the inquest report was not placed on record before the learned tribunal, and the insurance company also not produced any specific evidence, either oral or documentary, to prove the non-involvement of the offending vehicle. However, considering the fact that the offending vehicle was seized by the police authority on 21/07/2019 and police has submitted charge sheet accusing driver of the offending vehicle, I find no justification regarding the argument of insurance company for non-involvement of the offending vehicle. Thus, the same point is turned down. In considering the quantum of compensation as awarded by the learned tribunal, it appears to me that the learned tribunal has awarded a sum of rupees 19,60,000 as compensation of this case. In fixing the compensation, the learned tribunal has adopted a structured formula. The monthly income of the deceased was calculated rupees 10,000 per month. 40% future prospect was added with his income, and 1/4 was deducted towards the personal expenses of the deceased pair. Mr. Paul submits that the deduction of 1/4 towards the personal expenses is erroneous. In this particular case, the widow, minor son, mother and father of the deceased were made claimants. Further, claimant number 4 father of the deceased was not dependent upon the income of the deceased. However, no evidences were produced by the claimants to prove that the father was dependent upon the income of the deceased. She argued that in this case, considering the observation of the apex court in Sarola Burma, the court deduction would be 1/3 instead of 1/4. introduced the claim application. In the claim application, the father of the deceased is placed as claimant number 4. Father is not a legal heir of the deceased to get any compensation. However, there is no evidence on record to show that the old father was dependent upon the income of the deceased. Considering the same, I find justification in the submission advanced by the insurance company. Accordingly, in this case, deduction towards the personal living expenses of the deceased would be 1/3 instead of 1/4. Thus, this point is decided in favor of the insurance company. Stop. Thank you.